application on appeal in the matter of Faulkner and others, and Vollin Holdings Ltd and others.
Mr. Glacier, just before you get going, I should say we're conscious that we are 7 minutes late and you're all operating to a relatively tight timetable, so we will make sure that the 7 minutes are made up at some point.
I'm most grateful for that indication. So I'll start by mentioning to the court that together with my learned junior, Mr. Lilly, we appear on behalf of the first appellant, that's Vollin, and the third appellant, Alden. Alden's only involvement in this case is that it is the successor in time shares of Vollin. But as I'm hoping the court is aware, we do not appear any longer for the second appellant, Minden Worldwide. And I'm hoping that your court has had a communication from our instructing solicitors, Alan and Ivory, in relation to the reason for that.
Yes.
Which is that they came off the record for Minden as at 1 minute after midnight on Friday morning of last week, pursuant to an order of Mr. Justice Miles, in the wake of the sanctions imposed by the United Kingdom government against Mr. Roman Abramovich.
Yes.
I know from Mr. Hollington and I have had a brief discussion about that outside court, and he's indicated to me that in light of that, he's going to make an application that so far as there is an appeal by Minden, that application be dismissed. I'm going to respectfully invite the court to deal with that at the end of our submissions, rather than letting it trench on the substantive submissions that I'm still going to advance on behalf of Vollin and Alden. But that's obviously entirely a matter for the court.
Mr. Hollington, is that something you want to say anything about now?
Just to say that we do apply for the Minden's appeal to be dismissed. Nobody appears for Minden. Minden has appealed, doesn't appear to pursue it. It follows in our respectful submission that the appeal must be dismissed.
Now, I think I can be confident in saying that our inclination would be that that's something that we should hear about during submissions rather than making any decision on it at this early stage.
So be it.
I'll just flag this as much for my learned friend's benefit as anybody else's. There's no formal application to that effect. So Minden is not itself aware at the moment, as things stand, that that application has been made.
And like any other aspect of the question, I think that could be parked for the moment.
Precisely. So I'm hoping that the court will have seen from its pre-reading that this appeal raises questions as to the approach the trial judge, Mr. Justice Adam Johnson, took to an express contractual duty of good faith. And he believed that that duty mandated fidelity to the spirit of the parties' bargain. And at a very broad level of generality, we do not dissent from that proposition. But we say he made errors of principle in his understanding of how such a duty of good faith works, and specifically how it mandates fidelity to the parties' bargain, and also in his analysis of what that bargain actually was, given the terms of the written agreements in this case. The court knows that this appeal is concerned with the court's statutory jurisdiction under section 994 of the 2006 Companies Act, excuse me, to grant relief in respect of unfairly prejudicial conduct of the affairs of the company. And as we pointed out in our skeleton argument by reference to this court's December 2021 judgment in Re King's Solutions Group, that's tab 40 of the authorities bundle at page 1917, unfair prejudice in this context means one of two things. Either a breach of the legal rules, which it was agreed would form the basis upon which the affairs of the relevant company would be conducted, or alternatively, a use of those legal rules in a way or for a purpose that would be regarded as wrongful inequity. Now, before the trial judge, the petitioners did not mount any case of inequitable conduct. And it is a point of pervasive relevance both to the determination of this appeal and to the analysis of how his lordship dealt with it at first instance, that the petition was founded instead solely on allegations, in fact a very large number of discrete allegations, of breach of legal rules. Allegations of breach by the investors of the 2013 shareholders agreement and of the 2013 articles, and by the directors appointed by the investors, either of those same articles or of their more general statutory duties under Part 10 of the 2006 Act. In the run-up to this hearing, there was formally a dispute between the parties as to how many of those allegations of breach of legal duty the trial judge sustained. As the court will, I hope, have seen, there were 2 case management conferences convened by my Lord Justice Snowden in February and April. And as the result of exchanges at those 2 CMCs, the difference between those 2 parties has now reduced to a very small compass indeed. I can start by inviting the court to take out the first volume of the court bundle and turn to tab 6. You have the first page there, which is page 82, which is the list of the 12 findings of breach of legal duty which we say Mr. Justice Adam Johnson made. And it was this document, this was appended both to our skeleton argument and to the grounds of appeal. So the appeal and the grant of permission were framed specifically by reference to this document. We said that there were 12 findings of breach. It's a little bit rough because, in fact, if you look down, you can see that some of these items, for example, item number 5, there are various different provisions relied on. But for current working purposes, we say that there were 12. At the February case management conference before my Lord Justice Snowden, the petitioners maintained there to be 1 additional finding of breach, which this list omits, which was consequently not subject to our application or permission to appeal. I'm going to deal with that submission in due course.
Sorry, I missed that one.
There was 1 additional finding of breach of duty, which the petitioners maintain was made by Mr. Justice Johnson, which is not included in our list of 12. I'm going to come on to that suggested additional breach in due course. But for the purpose of structuring my submissions to the court for the next day or so, I'm going to do it predominantly by reference to this list of 12. I'm hoping that the court has a route map which looks like this in landscape format, which was a document that it was proposed the lead advocates on either side should prepare at the last CMC. And that gives the court an overview, I hope will be of assistance, so that you can understand at any given point where I am in my submissions, which of the findings 1 through 12 I'm addressing, where you can see the counterpart of those findings in the agreed list of issues. And so, briefly turning over the pages of that, you can see that the first principal topic I'm getting to is Dr. Sachs's resignation from his employment and removal from the board of the company, which I'll call Cpgl, in March 2016. And at that stage of the argument, I'm going to do most of the heavy lifting in relation to the question, how does a duty of good faith work? What does it connote? And importantly, what was the constitutional settlement, quote unquote, in this case? Constitutional settlement, constitutional balance, concept which the trial judge came back to approximately a dozen times during the course of his judgment. So all of that's going to be within the first heading. And if things run according to time, I'm going to be most of the way through that before we get to the luncheon adjournment today. Over the page, the next thing I'm proposing to deal with is what I'm going to submit to the court are the implications if you accept the submissions that I'm going to make in relation to the nature of the constitutional settlement in this case. And I'm going to deal there with the groups of findings that you see there, 3 and 4, 7 and 8, 9 and 10, 11 and 12, and then also with the 1 additional suggested breach of duty, which I've already referred to, which Mr. Hollington suggests that the trial judge made. I'm then going to turn to a separate topic in a little bit more detail. The court will have seen from its pre-reading that the trial judge said both that Dr. Sachs could not be removed from us, and also that the way in which he was removed was improper. And that finding, finding number 2, I'm going to deal with separately, that process issue. And then that's going to take me at the next stage to dealing with the findings that the judge made, findings 5 and 6. in relation to the corporate governance of CPGL in the 7-month period between Dr. Sachs's departure in March 2016 and Mr. Faulkner's expulsion in October 2016. And again, if all goes according to plan, I'm expecting to be midway through my submissions on that at the end of the day. And then finally, I'm going to deal with points arising out of my learned friend Mr. Hollington's case. The first is a submission that he makes in his skeleton that, contrary to what we say, trial judge in this case did in fact make a finding of dishonesty or something like it, justifying an overall conclusion of breach of the clause 4.2 duty of good faith. And then I'm going to come on to some aspects of my learned friend's respondent's notice. And looking at the last page, the ambit of that has somewhat reduced, significantly reduced as a result of the 2 CMCs that I've already referred the court to. I'm going to make some brief prefatory comments about ground 1 and whether that should be dealt with now at all. And then your lordships will have seen from my skeleton argument, I also have a strikeout application afoot in respect of that portion of Mr. Hollington's ground 2, which is actually left as the result of the case management conferences. And I'm going to open that, assuming I have sufficient time, at the tail end of my submissions before having it to Mr. Hollington. So that is how I'm proposing to deal with the matters. And before diving into the substance, may I just make 3 brief housekeeping points? The first of which is that the court has an agreed timetable, which both my learned friend and I are hoping to stick to. There's a little bit of elasticity to the extent that there is a 30-minute contingency at the end of the Friday afternoon. The second point to make is that at various points in my submissions, I will be referring to the composition of the Cpgl board or the board of its subsidiary, Compound Photonics UK, and also to the shareholdings, which my the investors, as I'm calling them, Minden and Alden, had at any given time. Before trial, we prepared 2 tables which gave the trial judge a chronological account of how both of those evolved. And pursuant to directions which my Lord Justice Snowden gave, we prepared updated versions of the 2. At this point, I'll just give you the references. They're in the supplemental bundle. So the chronology of who was a director of which company at any given time is in the supplemental bundle, volume 6 at tab 110. And then in the supplemental bundle, volume 6, tab 111, is the chronological account of how our shareholding evolved over time.
And these are agreed.
I should just say the directorships are, I think in relation to the shareholdings, the petitioners have I don't want to put words in Mr. Hollington's mouth, but a concern that they don't have insight to be able to agree everything down to the last letter. But in very crude terms, the key inflection points are agreed. So in very broad terms, it's agreed that we started off, Vollin started off with about 30%. It's agreed that we went over the 50% point at a particular point, the 75% point needed to carry a special resolution of a particular point. And there isn't going to be any disagreement, but by the time we get to the critical events in issue, in March 2016 and onwards, our shareholders combined stood at very roughly 93%.
Yeah.
So with that out of the way by way of introduction, I'm now turning to the first and what will be the longest of the topics upon which I'm proposing to address the court, which is the judge's conclusions in relation to Dr. Sachs's resignation in March 2016. Mr. Hollington characterises it, of course, as an enforced resignation.
Could I just mention, my Lord, that there is an agreed chronology, which I don't think the learned friend mentioned.
Thank you.
And that's the slightly, well, substantially thinned down
Thinned
chronology,
version.
yes. Yes.
So starting with finding number 1. The court has seen from our skeleton argument that we submit that where parties bind themselves in contract to act in good faith towards one another, 2 things follow from that, other things being equal. The first is that they are obliged to act honestly towards one another, understanding honesty here in a sense that is sensitive to the commercial context. In effect, this is a duty to behave in a commercially relevantly moral way, and in what follows, for shorthand and clarity, I will refer to that as the autonomous duty of good faith, or the autonomous aspect of the duty of good faith.
Now, I know I'll see this in the transcript, but can you just give me the punchline again? You say it involves a duty to act in a commercially moral way.
Yes.
You prefaced with the phrase, all other things being equal. Is that going to be important?
No. I only say that, my lady, because obviously a contract, where it's an express term of a contract, the contract could derogate that from that in a particular way.
All right, we'll
So
go
that-
for the
so
time being. Ignore that
It doesn't matter.
wrinkle. Thank you.
So two aspects of the duty, other things being equal. The first is the duty of honesty, the autonomous duty. And the second is that that autonomous duty may warrant the implication of other, rather more granular obligations whose breach does not depend on any question as to morality. In effect, we suggest that the autonomous duty can act as a springboard.
Could you repeat, sorry, echoing my lord, could you just repeat that headline? The autonomous duty may warrant
the implication of other, more granular obligations whose breach does not depend on any question of moral or immoral behaviour. In effect, the autonomous duty can act as a springboard, supporting the implication of more detailed performance level obligations. And again, for clarity and shorthand, I will refer to those obligations as derivative duties. Derivative because they are derived from the autonomous duty. In my submissions in relation to the judge's reasoning as to his finding one, I'm going to take it in 3 stages.
No, before Lenfin does that, I'll say this at the beginning, and I won't say it again. We don't recognise any of these arguments from Lenfrin's written skeleton.
So I'm going to address the judge's reasoning to his finding one in 3 stages. At the first stage, I'm going to explain by reference to the case law why we say duty of good faith operates in the twofold way that I've just described. Second, I'm going to consider what the judge had to say about the bargain, or as he termed it, the constitutional settlement, or the constitutional balance in this case, whether that can be justified. Thirdly, I'm going to consider the case law about the mental state required for a finding of breach of what I'm describing as the autonomous duty of good faith. Beginning then with the point about the twofold nature of the duty of good faith, it will be of assistance to the court to start by reminding you of the core of the judge's reasoning on this topic. The judgment is at tab 8 of volume 1 of the core bundle, and for present purposes, if I can ask you to turn within that to page 170.
Sorry, can you give me the reference again?
Of course, tab 8, page 170.
170.
I'm going to look at paragraph 404 by the first hole punch. The court knows that at trial the judge accepted that we had a statutory right to remove Dr. Sachs as a director of Cpgl pursuant to section 168 subsection 1 2006 Act. But the judge held that we weren't able to either invoke that right or to threaten to invoke it. And that is quite specifically, he thought, where the vice lay in what the investors did in March 2016. I'm reading paragraph 404. At the trial before me, the relevance in Dr. Sachs's mind of the threat to withdraw funding developed some prominence. I'll come back to that. But even more significant in my view was the threat to use the majority voting power to remove Dr. Sachs if he didn't go. Dr. Sachs's evidence, which was not challenged on this point, was that he was told expressly at the meeting of 14 March 2016 that if he did not go, he would be removed forcibly under the relevant procedure in the Companies Act. That's the provision I've just referred you to. And just look at the last sentence now. But that is just what, in my view, the good faith provision, importing as it did the requirement of fidelity to the parties' bargain, inhibited them from doing.
So just to be clear, the judge is there saying, well, in effect, Dr. Sachs was removed, and you don't challenge that?
Well, we say he resigned in circumstances where, had he not, there's absolutely no question that he would have been removed.
And so when the judge says Dr. Sachs' position was effectively terminated, you don't challenge that?
Well, it's an inaccurate summary of what occurred for this reason. There's a meeting on the 14th of March, and as will be apparent to your lordship from other passages in the judgment, what happens is Dr. Sachs goes away from that meeting. There's a period of then 7 days, during the currency of which he has legal advice from the company solicitors, who were Field Fisher, paid for by the company. And at the end of that 7-day period, on the 21st of March, he resigns. And a point I've made in our skeleton argument...
Sorry, did you misspeak? He had legal advice from solicitors paid for by the company. Who were the solicitors acting for?
Field Fisher were acting for Dr. Sachs.
But
Yes.
how did the company pay for it? Is that recorded in the judgment somewhere? Anyway, it doesn't matter. But you say the company paid for Field Fisher's fees?
Yes.
Yeah. Sorry, the reason I asked was, but I actually thought you said it was the company's solicitors that gave him the advice. I thought it was independent advice, but paid for by the company.
Yes. I mean, I said the company solicitors in a very loose sense. So Field Fisher, as your lordship will have seen from other passages in the judgment, gave general corporate governance and other advice to the company. He was advised, I think, by a different partner of Field Fisher. It doesn't really matter much. But he was aware that Field Fisher had acted for the company and acted for the company in other matters.
Right, but they gave him what was ostensibly independent
Yes.
legal advice, but paid for by the company.
That is so. And as your lordship will have seen from the judgment and also from our skeleton argument, at the conclusion of that process, there was the requirement for a board resolution by the company, Cpgl, approving the terms of his severance. That was effected by way of a written resolution signed by, among others, Mr. Faulkner and Dr. Sachs themselves.
Yep. Sorry, I interrupted my lady. I don't know whether that was...
So I've just shown the court paragraph 404, and I wanted to show you where the basis for the conclusion expressed there is laid. That's back at bundle page 167. And the critical passage for this purpose is paras 391, starting on that page, continuing to 394 over the page. And I'm not going to read out the whole passage, but in very broad terms, what the judge did here was to hold that as a result of the duty of good faith, the investors were obliged to act with fidelity to the bargain. Clause 4.2 being the mechanism that enforced that compliance. And you can see the core of his reasoning on that on bundle page 168 in paragraph 393. Now, I'm very much in the court's hands. If you want me to read out the passage, I can, or alternatively, I can invite you to read it yourself.
Shall we just read it to ourselves?
Please.
So
Paragraph
393 is the one you want us to look at.
Please.
Yes.
So the court sees in the middle of that paragraph, 5 lines down from the bottom, they were bound to act with fidelity to the bargain. See paras 357, 358 above. And it's important to chase that cross-reference down to understand what it was that his lordship was looking at. You find that on bundle page 156. And at the top of bundle page 156, you see extracts from two decisions, a decision of Mr. Justice Morgan in a case called Barker Community Villages of Fulham, and a decision of Mr. Justice Voss, as he then was, in CPC and Qatari DR. And you see in both of those two extracts references to something called the spirit of the contract, which the duty of good faith acts to protect. Mr. Just uses those precise words. Mr. Justice Morgan refers to an obligation of faithfulness to the agreed common purpose. Those dicta, I suggest, pose the question of what it means in this context to speak of the spirit of a contract. It is clear beyond doubt that an express power in a contract or otherwise may be fettered by an implied contractual term. An example is the Braganza line of cases, which shows that a power to make decisions adverse to your counterparty, which is on its face expressed to be entirely at large, may be cut back by implied duties analogous to those to be found in public law. It is also clear that the use of a legal power may, in certain circumstances, be regarded as wrongful in equity, allowing equity to intervene. Familiar examples of that are cases such as Howard Smith and Ampol in the Privy Council, and more recently Eclairs and JKX in the Supreme Court, which tell us that an exercise by directors of their legal powers for an improper collateral purpose may be set aside in equity. But in our submission to the court, absent either an implied term or intervention by equity, there is no basis upon which a party to a contract can be prevented from relying on its legal rights by reference to a putative spirit of the bargain. To borrow words Lord Hoffman famously used, albeit in a rather different context, in Law Glen in 1997, there is no, and I quote, penumbral spirit which strikes down devices or stratagems, unquote, and which operates at some level other than the orthodox level of construction. So if that's right, when we see references to the spirit of the contract in the context of discussions of the duty of good faith, how are we to understand them? In our skeleton argument, we suggested that a principled answer to that question can be derived from Mr. Justice Leggett's seminal decision in Yam Seng, which the court will find in volume 7 of the Authorities Bundle at tab 56. This is the fountainhead for the modern English law in relation to implied terms of good faith, and I'm sure that it will be familiar to all of the members of the panel. I do respectfully suggest we need to look at it in a little detail. And before we look at the general discussion of the principle which it contains, which is often cited, I suggest we need to understand the facts with a little care. What had happened here was that the defendant had granted the claimant a right of exclusive distributorship for branded toiletries in a certain territory. The relevant agreement was described by Mr. Justice Leggett as skeletal. And if you turn on in the bundle to bundle page 2348, you can see just how skeletal it actually was. If you look at the bottom of 2348, beneath letter H, the agreement, the distribution agreement is a short document evidently prepared by the parties themselves without the assistance of lawyers. It consists of 8 clauses as follows. And then you can see the whole of it is set out in less than a sheet of A4 on the next following page. Just over a year after this agreement was concluded, the claimant terminated it, alleging repudiatory breach by the defendant. The claimant alleged that there had been an implied term of good faith performance. And if you would go on now, please, to bundle page 2362, you can see it said that obligation had been breached in two specific ways. Looking at paragraph 83, it's only 3 and 4 that are relevant. So reading 83, it's Yamseng's case, the claimant's case, that ITC, the defendant, committed breaches and demonstrated an intention to commit further breaches, which justified Yamseng in terminating the contract. In summary, the breaches alleged by Yamseng are 3, undercut the duty-free prices. ITC undercut the duty-free prices agreed with Yamseng by offering the same products for sale at lower prices in the domestic market of the same territory. And 4, provided false information on which ITC knew that Yamseng was likely to rely in marketing the products. Then if you go on, please, to bundle page 2378. You can see the discussion of those two individual allegations of breach starts at paragraph 154 and runs down to and including paragraph 156 over the page. Could I respectfully invite the court to read those 3 paragraphs, 154, 55 and 56 to itself?
This only goes back to the final, the 4th breach identified.
That's absolutely right.
Right, okay.
And as your ladyship can see, his lordship starts with the point that the allegation is that the duty is a duty not to supply false information. And what he says is there's no such duty, but that the duty is a duty not knowingly to supply false information. And if you turn on to paragraph 171 and bundle page 2381, you can see how Lord Leggett dealt on the facts with that more circumscribed duty that he was prepared to find at paragraph 171. There can, however, be no doubt that objectively, underline that word, whether Mr. Presswell recognised it or not, his conduct in leaving Yamseng with the belief that the domestic retail price had been increased to $65 when Mr. Presswell knew that to be untrue was dishonest. So that's a finding of dishonesty by the reference in the first line to objectively. You no doubt that objectively we supplied the answer to that in our skeleton argument, and you can see it for yourselves if you turn back now to bundle page 2376. Look at paragraph 144 and just quickly cast your eye over that in the first couple of lines on the next page.
Well, you have to be very careful about the last sentence in particular of this paragraph, because clearly the court is concerned with subjective understanding. It's then a question of, by reference to that subjective understanding as found, whether objectively that is dishonest, commercially immoral, or whichever way you want to put it.
Yes.
And we see that when you see which reasonable people in their situation would have had. I don't know whether you're dealing with this now, but...
I know he's right. And, of course, this decision dates from 2003, so his
13,
lordship...
13, yeah.
Forgive me, 2013. So his lordship deals with it by reference to Robber and I. Similar points could be made by reference to subsequent cases,
Yeah.
Genting and Ivy Casino and those sort of cases. What they basically tell you is if what you did on any objective view is dishonest, it doesn't matter because you operate on some unique system of morals of your own that you didn't appreciate it. If you believe it's improper to charge people for travelling on public transport and you get on a bus and you refuse to pay, it doesn't matter that you don't think you're dishonest.
I mean, I absolutely follow that's how you put it, and it makes a lot of sense. I'm not quite sure that's what Mr. Justice Leggett meant, but that perhaps doesn't matter. I mean, he did refer to Royal Brunei, but then he's, in that last sentence, fairly explicit that we're not concerned with subjective intentions, but presumed intention. But anyway, it doesn't perhaps matter, given, as you say, the line of authority through to Ivy and
Yes.
Eurotrust and so on.
With appropriate respect to the judge, imputed might be a more appropriate expression to use than presumed. What Ivy tells you is that you find the facts.
You find what
Yes.
people
Actually.
subjectively thought and then decide whether that was objectively dishonest.
Exactly. And I haven't laboured the court with the authorities on that because that's reasonably established law and there's a great deal of authority in the bundles as it is.
Yes.
Your Lordship has precisely. But in any event, leaving that point to one side without wishing to brush it under the carpet, this is Lord Justice. This is Mr. Justice Leggett's discussion of the duty of what I'm calling the autonomous duty, the duty of honesty. And then for his discussion of the second of the two duties, which the claimant argued could be derived from that implied duty of good faith, you need to go to page 2379. Now, I will read these extracts. The whole passage from 157 through 164 is relevant, but I'll just read out the key bits there. So the heading to 157, a duty not to undercut duty-free prices. The second more specific term the claimant contends was implied in the agreement is a term the defendant would not prejudice the claimant's sales by offering the same products for sale within the same territories at lower prices than the claimant was permitted to offer. 158, as pointed out by counsel for the defendant, this alleged term is formulated doesn't accord with the facts, as the defendant didn't make any direct sales in any territory. 159, the highest the putative implied term could therefore be put is as an obligation not to approve a retail price for the product for any domestic market.
I mean, to what extent does all this help us in the context of an express good faith clause?
Well, it is of course conceivable that the way in which the good faith clause is expressly framed could mean that this reasoning were inapplicable. But we'll go to the duty of good faith in this case in a moment. And when we do, we'll see that it is imported simply, in effect, as a freestanding concept. The agreement is drafted by eminent city solicitors on both sides, and they import what is effectively a legal term of art. And for the purposes of my submissions, I'm going to say it makes no difference whether in any given relationship the duty of good faith is implied or whether it is expressed, subject, of course, to the precise wording in which it is expressed.
Following up on my latest point, Ms. Justice Leggett was concerned with implied duties of good faith and derivatively or otherwise the two specific duties you've drawn our attention to. The two specific duties in the context of the express duty of good faith we find don't obviously arise as such because they would be not aspects of the duty of good faith but separate implied terms, presumably.
My Lord, I'm not sure I'd accept that. So where I'm headed to is if you drop into your agreement a clause that says the parties will behave towards each other in good faith, what you've done is to incorporate within it the core duty of honesty, what I'm calling the autonomous duty. It's a moral duty. That duty may then, on the facts of an individual case, warrant the imputation of implied terms.
That I have trouble with. I can see that you might say on particular facts, conduct of this kind is a breach of the express duty, but that's different from saying that there's a separate implied term.
Well, the arguments that would arise in relation to whether or not there was an implied term will in any event arise in relation to the question of whether or not there has been a breach of the duty of good faith. Because if you have a contractual framework that expressly permits you to do 1, 2, 3, 4, and 5, and you do it, then whether you say that prevents or precludes the implication of a derivative term, or whether you say, well, that cuts back the ambit, that is relevant to the construction of the ambit of good faith which the parties have accepted, I respectfully suggest you get to pretty much the same point.
And I understand that argument. Just going back a stage, in terms of the overarching Mr. Justice Leggett thesis, and you're saying, well, there's no difference between an express contractual duty of good faith and an implied contractual duty of good faith. Mr. Justice Leggett, earlier on in his judgment, is not tying himself simply to honesty. He says, well, there's fidelity to the party's bargain, and he explicitly says somewhere that he thinks it's a good idea to think of it as a duty of good faith and fair dealing, because that distinguishes the relevant concept of good faith from other senses in which the term good faith is used.
I'm going to come on very specifically in a moment after taking your Lordship through the facts to what Mr. Justice Leggett says about fidelity to the bargain and the scope of how that works. And it may also be helpful if I just make this point to the extent that your Lordship's concern is that this is a decision dealing with the implied rather than express duty. I'm going to go to a number of other authorities during the course of later this morning and probably earlier this afternoon in relation to other cases where the ambit of the duty of good faith is considered. One of them is a decision of this court in a case called Carroyne, Lady Arden, Lord Justice Morbeck and Lord Justice Reimer, and that is expressly concerned with a duty of good faith and, very importantly for the purposes of this discussion, also with a duty to adhere to the spirit of the bargain. And the point that I'm going to be making to the court in due course is that when you look at the two decisions, when you look at the way in which we are respectfully inviting you to read what Mr. Justice Leggett says in Yam Say, and how the Court of Appeal deals with the express issues that arise in relation to good faith in Carroyne, they are ad idem, and interestingly, Yam saying doesn't appear to have been cited in Carroyne. It was only decided 5 months later. I will come back to that in due course.
Yep.
But just keeping, if I may, so I was just showing you how His Lordship in this case dealt with the implied duty not to undercut. And then at paragraph, I've shown you 157, 159, 159, he says the highest the putative term could therefore be put is an obligation not to approve a retail price for any product for any domestic market which was lower than the duty-free retail price agreed by Yam Seng. 160, ordinary circumstances, I wouldn't see any justification for that. End of the paragraph. 3 particular contextual features lead me to conclude there was, in fact, such an implied term. 161, the first is the agreement is a skeletal document which doesn't attempt to specify the parties' obligations in any detail. And then at 164, in my view, these matters taken together lead to the necessary implication, note the words necessary implication, that ITC would not authorise the sale of any product in the domestic market of any territory covered by the agreement at a lower retail price than the duty-free retail price of the product specified in the agreement with the claimant. So that's the term which the judge derives from the implied obligation of good faith. And then for his finding of breach...
I mean, I followed that in a sense, but actually that's a perfectly conventional basis for an implication of that freestanding term.
My Lord, I accept that. On the face of the judge's judgment in this case, as a proposition of fact, he does derive that term from the obligation of good faith.
Yep.
But your Lordship's point is, if I may respectfully say, well taken, because when you look at the decision of Lord Justice Morbeck in the Court of Appeal in Carr, his Lordship in that case makes a very similar point to the effect that does good faith really add anything? But I'll come back to that in due course. But on the face of the judgment, what Lord Leggett was doing here was to say there's an obligation of good faith in the context of what is a relational agreement. You breach it if you are dishonest, and it may import derivative terms as to performance, even if those are not set out in the context of the skeletal agreement. And then for his finding of breach, you go on to paragraphs 166 and 167 at the bottom of page 2380. And can I just invite you to read 166 and 167 quickly to themselves? The details don't matter, it's just to get the flavour.
I'm sorry to press you on this. I'm just struggling to find, and I may have missed it, but where are the two duties we're looking at
Right.
treated as derivative as opposed to being considered as whether or not they exist as implied terms in the normal way?
Yes.
I suspect it's 154. Really.
That's it.
Yes. And 155. The first more specific
Relevant
term.
content of the duty was captured by two more specific times.
Exactly.
Right.
Exactly.
It's not that clear, is it?
No. So then if you look, I suspect more directly to the point we've just been focusing on, my lady, at 157, the second more specific term, which I'm saying contends was implied.
Yes.
I mean, that one in particular doesn't obviously look like anything to do with good faith. It's
No.
yeah.
No. So if you've read paragraphs 166, 167, you've seen what Mr. Justice Leggett says about breach, and there are 2 points in my submission to get out of the passages that I've just taken you through. The first is that although this implied term about not undercutting appears to have been derived in part by Mr. Justice Leggett from the autonomous duty of good faith, whether it has been breached or not has nothing whatsoever to do with the morality of the defendant's behaviour. Breach turns simply on a hard-edged question of fact, whether the defendant had or had not agreed lower prices with another retailer. And the second point to make, when we looked at bundle page 2380, paragraph 164, a moment ago, I emphasised when I read out in the first line, lead to the necessary implication. I emphasise that because I suggest it is as clear as it could be, as you would expect, that this derivative term about not undercutting has been implied by the judge in accordance with perfectly conventional principles about the implication of contractual terms, as now expressed in Marks and Spencer. Don't need to take your lordships to it, but if you need it, it's in the authorities bundle at tab 24. And that is why Mr. Justice Leggett refers to it in his paragraph 164 as being a necessary implication. So having done that groundwork on the facts, I can now take the court back to the familiar discussion of principle earlier in the judgment. And there are 2 key passages. The first starts at bundle page 2374. And in our skeleton argument, we submitted, following similar comments made by others, we claim no originality in it, that the innovation of Mr. Justice Leggett in this case was to say that a key part of the background for the purposes of construing a contract is the parties' shared assumptions about behavioural norms. And if you look at paragraphs 133, 34 and 35, that is the point that you see his lordship making there. And if I can invite you to cast your eyes over that passage. if your lordships have that, that discussion feeds into the second of the two key passages which you find over the page at bundle page 2375. And starting there, if you would, and I think this addresses the question Lord Justice Newey was asking me a moment ago, start, if you would, by just looking at how he begins paragraph 140, the two aspects of good faith which I have identified. So he's talking about two separate points, and the first point he deals with at 137 through 138, and then the second one is the one he deals with at 139, starting with the words another aspect of good faith. So if I can ask you also now, please, to read 137, 138 and 139.
So the two aspects, honesty and fidelity to bargain.
Yes. So, engaging directly with Lord Justice Newey's question, does the judge say that this point about good faith is relevant to implication? In this judgment, he certainly does. And that second point, 137 and 138, is what I'm terming the autonomous duty. And then 139 is the point I'm capturing in the possibly slightly clumsy expression derivative terms. And you see that so far as that second aspect is concerned, Mr. Justice Leggett expressly refers to fidelity to the party's bargain. That's the second line of the paragraph. That is, of course, closely similar language to the language of Mr. Justice Morgan and Mr. Justice Voss, which you've already seen in the two cases cited in Mr. Justice Adam Johnston's decision. And in fact, if you go on to paragraph 140, you can see that's no accident, because those are precisely the two cases he has in mind. Paragraph 140 refers specifically to Berkeley Community, Mr. Justice Morgan, and CPC, that's Mr. Justice Voss's case. But the critical point to note is that when Mr. Justice Leggett talks here about fidelity to the party's bargain, he is not saying that the duty of good faith bypasses ordinary principles of construction by enforcing adhesion to some noumenal spirit of the contract. He is saying that it can mandate the implication of ancillary terms.
Now you say that. Where does he say that? Is this not part of the overarching duty of good faith and fair dealing, which he sees as implied?
My Lord, with respect, no, for two reasons. The first is the discussion that I showed your Lordship a moment ago about how he arrived at the derivative duty about not undercutting in this case. And I emphasised to your Lordship the conclusion which he came to, which was that it had to be a necessary implication. The word necessary obviously has familiar resonances. And the point is absolutely clear, I respectfully suggest, if you look at the way that it's discussed in paragraph 139, where he goes on to refer to some very familiar authorities in relation to the implication of contractual terms. Rainy Sky, TSB and Lloyd's. And it blends also into the prevention principle. You can see the reference in the penultimate line to McKine. So the critical point to take away is that to the extent an obligation of good faith entails more than a duty to act morally, it can only do that by supporting the implication of terms on the ordinary approach. And again, to flag where I'm going to get exactly the same proposition from the decision of this court in Carr. this point, this analysis of how the duty works is a point which we respectfully suggest the trial judge failed to appreciate in the passage in his judgment which I took the court to a moment ago, in which he attributed decisive significance to the dicta of Mr. Justice Morgan and Mr. Justice Voss about good faith mandating fidelity to the spirit of the contract. And as a result of what we say is that error of principle, as we pointed out in our skeleton argument, he failed to address the question of what fidelity to the bargain requires by reference to the standard tests for implication. You will find no mention in his judgment of Marks and Spencer or any of the other controlling authorities. And we submit that he allowed himself, with respect, to be beguiled by a submission that the duty of good faith meant that Cpgl was akin to a quasi-partnership, with Dr. Sachs and Mr. Faulkner having partner-like rights of participation in the business, even though, as we shall see in a moment, the contract here quite expressly provided to the contrary. That takes me neatly to the second of the topics I wanted to address.
Just before you do, can I just sort of think around that for a moment? You say that in looking at derivative terms, you would have to satisfy the tests for implication of terms in accordance with Marks and Spencer. On the face of it, we're not concerned with implied terms at all. We're concerned with construing an express term, which was not what Mr. Justice Leggett was doing in Yam's saying. If it were the case that Mr. Justice Leggett understood a duty of good faith to have comprised within it the two elements of honesty and fidelity to bargain, well, if we construe the express term in line with what Mr. Justice Leggett thought the implied term would be, then you are there. There's no need to look for any necessary implication because we're dealing with an express term, not an implied one.
Well, that may be right, but perhaps the answer to that is the one that I offered to your Lordship earlier, which is that to the extent, and again to telegraph where I'm going, it's unclear how the judge dealt with this in his judgment. We say maybe an implied term, and a friend says no, it wasn't. But park that argument. One still arrives conceptually at the same question. Because if you say to yourself, well, the duty of good faith mandates fidelity to the bargain, the question then becomes, what is the bargain?
I mean, that I understand.
And if the bargain...
I entirely understand that, but just thinking around it for a moment, Yam Singh is a case on implied terms. We're not dealing with an implied term, we're dealing with an express term. And in the context of express terms, actually we have authorities dealing with what one might understand the express term of to mean. You refer to Coroyne. There's also Berkeley, CPC, F&C. I mean, are those not the more obviously relevant authorities?
My Lord, yes. The reason I've started it with Mr. Justice Leggett's decision, I'm fully alive to the distinction between an implied and an express term. But the reason that I've started with that is because the train of authorities that I'm going to take you through in a moment, and I say there are 6 that are really relevant for this purpose, all of them bear out 3 propositions. The first is the distinction that I've drawn between what the essence of the duty of good faith is and what it may entail. As I put it earlier, the distinction between autonomous and derivative duties, but they may not be very useful expressions. Secondly, what the essence of that duty of good faith is. And as I've already indicated, we say that that is a contextually sensitive concept of honesty. And then thirdly, whether you approach it as a matter of implication or whether you approach it rather more generally as a question of Well, if it mandates fidelity to the bargain, what is the bargain? On either view, the exercise is a conventional application of principles of construction. Going back to the point I made earlier on, it is not something akin to what Lord Hoffman once stigmatised as identifying a penumbral spirit that strikes down devices and stratagems.
Give me the reference to the Lord Hoffman case again.
I mentioned Norglen, 1997. I'm afraid it's not in the bundles. We can supply your lordship with a reference after the adjournment, I'm sure.
Because, in fairness to, I understand for myself that's very helpful, particularly your third point, but what Mr. Justice Leggett wasn't doing was exploring this interaction between an express good faith clause and the implication of terms, which is why the answer isn't necessarily readily to be found there.
Yes.
Because he was saying you hardly ever have good faith clauses.
Well,
express clauses.
yes, not then.
Yeah, understand.
So, though actually, this clause dates from 2013, and
Yes.
it was a predecessor in 2010,
Yes.
presumably.
Right.
Yes. And it's important to say, I mean, this is, in a sense, obvious. In the light of the tradable authorities since 2013, even if you don't have an express term of good faith in a shareholders agreement, which is going to be regarded inevitably as a relational agreement, absent express provision to the contrary, there's a strong chance that a term is going to be implied to that effect. So the implications are obviously quite pervasive.
Could I mention for your Lordship's assistance that on the 4th of April of this year, the Court of Appeal did address the question of the meaning of an express duty of good faith in the Soteria insurance case, which came too late to be mentioned in the authorities, in the skeletons, but which your Lordship will find in the very last tab of the bundle of authorities.
Yeah.
So I was coming on to the second topic I was going to deal with in relation to Dr. Sachs's resignation, which is the judge's analysis of what the bargain here actually was. So the constitutional settlement or the constitutional balance, as he repeatedly called it. And just before I embark on that, let me deal with one point. You will have seen from your pre-reading that in his skeleton argument, Mr. Hollington complains about what he says is a change in emphasis between how we put our case in writing when we got permission to appeal from Lord Justice Wilby and how we put it in the final replacement skeleton we prepared pursuant to the direction Lord Justice Snowden gave in February. Mr. Hollington complains that whereas we originally majored on the point that the breach of what I'm calling the autonomous duty required a finding of dishonesty or something like it, we are now instead focusing our attack on what the judge about a constitutional settlement. I'm not going to take up forensic time debating whether or not he's correct about that. We say he's not. But in the light of the point, it may still be helpful just to show you what our grounds of appeal said about this. And that's back in the core bundle at tab 17. Sorry, that sounds unlikely to be right. Tab 1, page 17. And turning over to page 19, it's enough to show you paragraph 3 there. So this is dealing with finding 1, Dr. Sachs's removal. And can I just ask you to cast your eye fairly quickly over that? The key paragraph for this purpose is what we say in 3.2 and 3.3. So looking particularly at what we said, 3.2 on page 19, it is, I hope, perfectly clear that we are and have at all times been attacking the conclusions the judge reached about what the constitutional settlement was. We've always been dealing, among other points, with the question if good faith mandates fidelity to the bargain, what was the bargain? So far as that is concerned, we can see what the judge had to say about that if we started off on bundle page, tab 8, same bundle, page 150. On page 150, picking it up at paragraph 335, beneath the second hole punch, under the heading Petitioner's Case in Outline, 335, critical to both sets of submissions is proper understanding of what can be called the parties' bargain, i.e. the constitutional settlement, arrived at first in 2010 and 2013. Mr. Hollington's contention on this general point of characterisation was that the 2013 Constitution gave rise to what he called a contractual quasi-partnership. Mr. Hollington clarified that in making that submission he wasn't seeking to rely on any oral assurances. Instead, his case was based on a reading of the constitutional documents looked at and around, and of course against the background of the matrix. Mr. Hollington said reading the constitutional documents in this way disclosed two particular agreed common purposes, namely 1, entrenchment of the positions of management of Sachs and Faulkner, and as its corollary, 2, the prevention of Vollin Holdings Ltd from obtaining control of its Cpgl board. Mr. Hollington argued that both those purposes have been overridden and frustrated by the actions taken by the investors from March 2016 onwards, in breach of their obligation of good faith under clause 4.2, and consequently that the petitioners have been treated in a manner which was both unfair and prejudicial. So Mr. Hollington was proposing the creation of a new category of cases as a well-established category of quasi-partnership companies where the legal rights have an equitable gloss. And the suggestion here is that there is in effect a quasi-partnership situation where the obligation of good faith, although not imposing an equitable gloss, imposes some supervening gloss on the parties' legal rights. And the court can see the judge's discussion of that submission by turning on, first of all, to paragraph 340, down further on page 1.
Just before we go there, can we just get our bearings on what the arguments in front of the judge were? Because Mr. Hollington's argument as set out was that the constitutional documents entrenched the positions in management and effectively made Dr. Sachs and Mr. Faulkner irremovable. Correct? Your arguments at paragraph 337 were extreme in the other direction, weren't they? Apparently, you are recorded as having submitted that there was nothing which inhibited the statutory entitlement of the majority to remove the directors if they saw fit to do so for whatever reason, which is no restriction whatever on the right to remove derived from the shareholders' agreement. Is that right?
Well,
and the reason, before you ask the follow-up, just to be fair so you know where I would be going, is that when you showed us paragraphs 393 and 394 of the judgment, they were expressed by the judge in what might be regarded as a rather caricatured way, in the sense that he talks, for example, at the tail end of 393, it makes no real sense to say that the investors retained an entirely unrestricted right to drive a coach and horses through the constitutional settlement by virtue of the majority power, and the like. So that, as I understand it, the way that this seems to have been argued, at least provisionally, is that on one side they were saying that the effect of the bargain, the articles and the shareholders' agreement, was entrenchment, absolute, irremovable, whatever. And on the other side, it's no restriction at all. It makes no difference. We can remove for whatever reason. We have an the way in which the parties were going at this in front of the judge?
No,
Right.
because the submission that was made to the judge, surprisingly, was that it all depends on the facts. Now, as your lordship will have seen from pre-reading the skeleton arguments, at trial, we faced, just confine the argument for a moment to Dr. Sachs's removal. There were various allegations of fact which were pleaded as sustaining the allegation that we had actually acted subjectively in bad faith. There was first and foremost a suggestion that oral representations had been made to Dr. Sachs and Mr. Faulkner before the agreement was ever signed that they would be removed. There was a suggestion that we had committed to unlimited funding beyond the 20 million that we originally put in. There was a suggestion that before these discussions with Dr. Sachs in March, he was never told that funding was in doubt. And then there was a tail-end suggestion that Mr. Fletcher, who was Vollin's advisor, had deliberately run Dr. Sachs down and discredited him with the investors. All of those factual submissions in support of the proposition that we had acted in bad faith failed. And we said to the judge, whatever the parameters of the power of removal are, against the background where there were the most compelling commercial reasons to remove Dr. Sachs, we were entitled to do it. And all clause 4.2 does is to impose a duty of honesty. So I hope engaging directly with your lordship's question, that the straight answer, as I said, is no, because we said that on the facts as we submit them to be, where we had not acted in any of the bad faith ways which had been alleged, and where, as the judge accepted, we had compelling commercial reasons bona fide for wanting to see Dr. Sachs gone, we could do it.
Right, but I'm trying to understand, you were just about to embark upon what is the bargain, identification of what's the bargain. I'm just trying to understand, you either were not or you are not now saying that the bargain was that you could remove for whatever reason or no reason at all, just simply as they saw fit.
I didn't
Because I'm just looking at 337. The judge records your submission as the bargain is that there was nothing which inhibited the statutory entitlement to remove the directors if they saw fit to do so for whatever reason. Are you submitting that is the bargain? Is that still your submission that that's the bargain? Or do you accept that the bargain is that there may be circumstances in which removal is permitted, but they have to be has to be justified, identified, or in some way? I'm just trying to understand before we get to what you say the bargain is, the way you record it, as I understood the judge's judgment, as having submitted that the bargain was we can remove as and when we see fit, and Mr. Hollington's side was you can't remove at all.
So the straight answer to your lordship's question is that the submission to the trial judge, I think, I'll be corrected, I'm sure, by somebody if I got this wrong, was that there was a right to remove as shareholder and as an employee, and that within what was on its face an unrestricted right to remove, there was a moderating influence imposed by the duty of good faith conduct. And also, and this is a point I'm going to come on to with your lordship in a moment, there was specific provision in the shareholders agreement in relation to the exercise by shareholders of their rights. And it's a separate provision than provision in relation to good faith. I'm going to take your lordship to that in just a moment.
Okay. We do have somewhere, don't we, your closing written submissions at trial, which presumably reveal exactly how you did put it.
Yes. I think it may be fair to say that the legal submissions were more fully developed in the written opening. And then the closing submissions, they do touch on some questions of law, and that's what we're going to come on to in a moment. Closing submissions were more weighted towards the factual issues that are raised.
The evidence that had emerged. Yes, I see.
And just to follow up, the bargain which we're about to encounter is to be found as an exercise of interpretation, you say, I think, in the articles and the shareholders' agreement as construed against the background of company law.
Yes. And your Lordship bears in mind that so far as Dr. Sachs is concerned, there's a twin capacity in play. He is a director, so prima facie susceptible to removal under the provisions of the Companies Act, subject to the articles and the shareholders' agreement. And he's also an employee. And the circumstances in which he can be removed in that separate capacity are dealt with in an agreement I'm going to come to in a moment, which is his services agreement. So,
Just
yes.
going off at a tangent briefly, of course, most of the petitioners aren't either Dr. Sachs or Mr. Faulkner. And so far as they're concerned, perhaps the picture is a slightly different one. I mean, the judge's theory is they had backed Dr. Sachs, and they were entitled to have that respected.
Yes. There wasn't. There isn't much discussion in the judgment about the possibility of a difference between prejudice from acts to Dr. Sachs and Mr. Faulkner, and prejudice to the other shareholders, none of whom gave evidence. And that's an issue which conceivably, for example, may raise issues down the line, probably not for this hearing, but down the line. If, for example, the only finding, speaking purely hypothetically, working with standard court scrutiny of this appeal, is the finding in relation to the process by which Dr. Sachs was removed.
Remind me, the other shareholder, all the petitioners are or are not parties to the shareholders' agreement?
They are.
So there's no distinction. If this case turns on what does clause 4.2 mean, there's no distinction between the position of Dr. Sachs and the other petitioners, because they're all entitled to have it respected, whatever it means. If you breached it, on the face of it, it's unfairly prejudicial to them because it was the agreement by which the affairs of the company in which they'd invested was to be conducted. And if you didn't breach it, then subject to breaches of directors' duties as a separate topic, perhaps, there's no unfairness to them because the contractual and provisions of the articles and the shareholders' agreement have been complied with. Is that a fair?
Yes. I mean, the better way of expressing the point may be that if it is merely a procedural, I say merely, I'm not saying that to belittle it, but just forensically, merely a procedural issue, the same result could have been achieved in a controlled way. And there may be a question about prejudice. But as I say, that's not a matter.
Yeah.
I'm proposing to get into certainly.
And just before we get, because I think you were about to take us to, so which was the next paragraph you were about to take us to?
Well, I was going to take the court to paragraph 340. So I've just shown you Mr. Hollington's suggestion of the contractual quasi-partnership.
So 348, did you say?
No, 340.
Sorry.
On Polygon page 151.
All right. Well, I'll hold the question until you get to the one that I did want to ask you about then.
So I'm now looking at the passages in the judgment which deal with the judge's analysis of that submission of quasi-contractual partnership. And you can see at 340 that I started off by citing to the judge provision of section 168, founding the right of removal. 342, the judge says over the page, well established that in some cases there could be another dimension, meaning that although the effectiveness of the decision to remove the director cannot be impugned, the act of doing so may nevertheless infringe some other right of the director shareholder in question. He then says the paradigm case is that of quasi-partnership, as exemplified in Westbourne Galleries, where the right infringed arose from an agreement binding in equity. The minority shareholders would not exercise their undoubted power to expel the minority from the business. That agreement in turn had its origins in the fact that prior to incorporation, the parties' business had been carried on as a partnership. And then finally, for this purpose, turning on to bundle page 153, And looking at 345, in Ebrahimi, the right or entitlement invoked by Mr. Ebrahimi was based on an agreement or understanding binding in equity, but it seems to me there's no reason the right can't be a legal right, arising as a result of an agreement between the shareholders. And then you see what he says at paragraphs 346 and 347, and if I can invite you to read those to yourself to make up the time.
Yes.
And you can see the last sentence, 347, the central question, therefore, is whether the good faith provision can be read in that way, whether it can bear the weight Mr. Hamilton places over it. Turn over the page, 154.
Right.
This question is essentially one of construction.
Right. Now, do you, first question, if I may, do you accept that the judge was asking himself the right question in when he phrased it the way he did in paragraph 347?
To the extent that the judge is saying that the question is a question of construction, I accept that that is the right question.
I know you say you got the wrong answer, but the question, that's the question.
It
That's
is a question of
the
construction.
fundamental question. Second point I was going to ask you about those paragraphs. The judge seems to proceed upon the basis that it would always be possible to, as a matter of company law, for shareholders to remove a director under section 168. And he said the legal effect of the expulsion is not unwound, but other legal consequences may follow. Is he right? I mean, if you have a shareholders agreement which says, let's say, Director A shall remain at all times a director and be involved in management, and that is threatened to be breached, why can't a minority shareholder go to the court under section 994 and say that is a threatened breach? It is a threat to commit unfairly prejudicial conduct. I am entitled to restrain the removal in the way that Dr. Sachs could, I think, if this judgment is right, have prevented its removal in the week after the 14th of March.
My Lord, the straight answer to your Lordship's question to me is no, the judge is wrong. And it's a submission that I'm going to develop to your Lordship in a moment. In fact, what your Lordship has just said is interesting while we're still on this page, because if you look at paragraph 345, where the judge gives us authority for this proposition Russell and Northern Bank.
Yes, well, have we looked at that? Is that in the bundles?
I don't think it is. We can do, but the point that I was going to make is that is precisely the situation that my Lord Justice Snowden envisages, where the act in question is the subject of an application for an injunction.
Yeah, Russell and Northern Bank, as I recall, is an unusual case because it was somebody that said, well, the company has bound itself not in the circumstance, I think it was to alter its articles, I believe, or alter its memorandum. Yeah, the company has bound itself to not to do something which the Companies Act says a company can do. Yeah. And the House of Lords said that is not permissible. You cannot override statute by private contract binding the company. But, they said, it is permissible for shareholders to agree between themselves how to exercise their voting rights, which may have the same ultimate result, but the injunctions, if they lay, would lie between the shareholders as a matter of contract. Now, but in 994 terms, it must, the very section talks about giving relief in respect of actual or proposed conduct of the affairs of the company. So your answer is the judge was wrong to the extent that he thought that Section 994 only permitted retrospective relief rather than prospective relief in relation, for example, to removal.
Yes. I'll come on to this in a moment if I may. But the essence of whether, and I'll show you another passage in the judgment where this is even clearer. The essence of what the judge does is to say, well, there may be the right, but if it is exercised, you have a remedy retrospectively for unfair prejudice. But you can't stop it.
Yeah.
And we suggest...
You say that's, well, simple terms, pretty counterintuitive for a start.
Yes. Yes. I'll come on in a moment. There's another passage which makes this even clearer, and I'll develop a submission by reference to that if I may. So I got to the top of page 154 where the judge says the question is a question of construction, and we agree with that. You then have, if you turn on down to page 165, what actually happens at that point.
Yeah, and just to pick up the point, the judge actually goes, I think the judge actually goes wrong. Right at the start, doesn't it? Paragraph 341, you'd say, sorry, see what Hollington says, but section 168 provides that a company may by ordinary resolution remove a director, notwithstanding anything in any agreement between it and him. And then 341, he says the section thus gives to the majority shareholders in the company an inalienable right to remove a director from office. I mean, he's wrong there, isn't he? The majority shareholders can alienate that right, yes, in the sense that they can agree by contract with somebody that they will not exercise their votes in a particular way.
Yes. They can bind themselves.
The company can't promise not to remove somebody as a legal entity, but the shareholders definitely can.
Yes.
And that's the Russell and Northern Development Bank difference.
Yeah. So, my lords, I was on bundle page 154, paragraph 348, first line. The question is essentially one of construction. And then what actually happens is there's 10 pages running all the way down to page 165, in which the judge, having characterized it as a construction exercise, discusses the authorities. And his actual engagement with the construction issue, you then get on bundle page 165 at paragraph 382, where, having got the authorities out of the way, he says, I come on then to analyse the parties' bargain in this case. And looking at 383, you can see he excludes the relevance of pre-contractual negotiations and makes the point that agreements have to be understood in their contracts. And then at 384, he sets out what he believes the relevant context to be. And then the critical passage is the passage that you get at 385 through 386, where he sets out certain features of the agreements on which he places particular reliance. 385 seems to me, approaching it broadly, the structure arrived at and contained in the constitutions was a compromise designed to hold a balance between these potentially differing sets of interests. Cornerstone of this constitutional settlement, designed as it was to maintain an acceptable balance of power between the existing and new shareholders, was the allocation of management responsibility for the business to Cpgl's board. More specifically, the allocation of responsibility was to a board having the particular characteristics described in the shareholders' agreement and the articles. Crucially, those characteristics included the following, and I'll gloss over those if I may. I'll come back to the detail of this a little bit later, but just to get the flavour of it, if you look at his little Roman 3, the point that the judge in very broad terms is making there is that when you look at the shareholders' agreement and the articles, Dr. Sachs and Mr. Faulkner have special rights in relation to things like majorities and in relation to quorum. So when he says it's not just a question of delegation to the board, he's saying it's delegation to a board having these special features which are personal to these individuals. So I'll come back to the detail of that in a moment. What it builds up to is the conclusion, which you see running from pages 167 to 168, paragraphs 391 through to 393.
Does it not begin with 390?
Yes. Yes. 390 through to 393. And paragraph I'm going to focus on at the moment is paragraph 393, which I showed you earlier on.
So is this right? As I understand 390, he says that whereas the normal situation is that the majority of shareholders can dictate the composition of the board by removing and appointing directors through their statutory power to do so. In this company, that situation was inverted, so that it was always the minority shareholders who were to have the majority on the board, and that could not be altered.
Yes.
Except it was altered in 2014, wasn't it?
That's a point I'm going to come to in a moment. But your ladyship is quite right. And nobody ever complained there was anything wrong about that. So the court has already read, or I've read to the court, paragraph 393. And my Lord Justice Snowden asked me earlier on about the effect of the submission that I made at trial. And in a nutshell, what I said to the trial judge was, against the context as it was in March 2016, there was nothing remotely improper in Dr. Sachs's removal. So that on the findings, in fact, he went on to make, by that point, we had invested £134 million in this company and seen not a penny in return.
Sorry, by March 2016, did
By
you
March
say?
2016.
Okay, I just didn't hear you, my fault.
£134 million. The judge found that despite that, despite the fact that for that massive investment we had seen nothing in return, even going into these critical sequence of meetings with Dr. Sachs in March 2016, we still had not taken a decision to oust him. That's paragraphs 132 and 136 of his judgment. And on the judge's findings, this is paragraphs 136 through 143, he found that we only changed our minds about that because at the penultimate meeting on Friday, the 11th of March, we said we wanted to appoint management consultants to find out what had gone wrong, but Dr. Sachs refused to grant those consultants unfettered access to the business. And despite all of that, which one might, with respect, suggest is quite a compelling reason to want to remove a chief executive, the judge found that we were not entitled to, with the consequences I pointed out in our skeleton argument, that effectively we were left with a binary choice. Either to continue to pile very substantial investments into a company run by a chief executive who had failed to deliver, or alternatively to stop investing, in which case the company would have become insolvent in very short order, leading to the loss of everybody's investments.
Right, but this is key because the way you just put it, i.e. that there was a valid, genuinely held commercial belief on the part of your clients as to what was necessary to avoid the company becoming insolvent, was what you say was the justification for what they did. The argument the judge seems to have been addressing when he reached his conclusions in 393 and 394 was an argument that you could, at will, in an entirely unrestricted way, act so as to remove Dr. Sachs or Mr. Faulkner. And the judge seems to say at 394 that cannot have been what the parties intended. In other words, he seems to have been addressing an argument from your side that it you had an unrestricted right, irrespective of the background that you've just outlined, irrespective of the commercial belief that you've just outlined, to do what you did. Whereas the argument you're putting now is that there was a commercial justification genuinely held.
Yes.
And what I was putting to you earlier was trying to tease out was whether the way that the judge has reached his conclusion was a response to the way that the arguments were put.
I understand your Lordship's point. I think that the straight answer to your question, standing here, do I remember exactly how it was put in written argument with your submissions, is I simply don't remember. But I am reasonably clear, and no doubt we can go to this if we have to, that the way that it was put, there was a very specific basis for the allegation of bad faith on the pleadings. And our case to his Lordship was on the fact that it failed, and that in the circumstances obtaining at the time, there was nothing improper about what it was.
So if you look at 394, where my Lord is understandably sort of focusing for the phrase, for example, swept away at will, the bottom line is, you said in any event, it wasn't being swept away, the positions weren't being swept away at will in that sense. They were being swept away for, using a very inadequate term, a good reason.
Yes. It may be, as I say, what I said is what I said. I'm no doubt going to be shown that in due course. But just for your Lordship's note, for your Ladyship's note, if you look on page 172, at paragraph 416, about 6 lines up from the bottom of that paragraph, is what I recall being the way in which it was put by me. A finding which reflects the way in which I think I put it, where he says, what one is left with is essentially the majority investors imposing on Cpgl their own vision of what should happen commercially. In my view, it does not matter that the vision
Yes.
may have been a sound one.
Yes.
The point is that, good or bad, it was an expression of the will of the majority only. And that's a point which, in fact, I think the judge comes back to at a number of points.
419, for example, where
Yeah.
he says you justify the exclusion on the basis of a bona fide belief that it was right for the business from Dr. Sachs to go, and the judge says, I'm sure they did hold that view.
And we didn't get to the last sentence of 416. He says that the 2013 Constitution, which I think is of his broadening, was expressly designed to avoid the will of the majority prevailing in matters concerned with the commercial future of the company. As I understand it, he formed the view, irrespective of whether the company was going to succeed or fail, the 2013 Constitution, the bargain, was that Dr. Sachs and Mr. Faulkner had to remain on the board.
Yes.
To use an expression, perhaps, even if the horse was going to fall at the fence, they had to be the jockey on board.
Absolutely correct.
And nobody could change to avoid that occurring.
Correct.
Now, and my points to you have been put on the basis that that seems to have been the argument on their side. Your argument seems to have been, actually, we can remove at will, whatever the commercial background, whatever the commercial justification, and the judge was trying to arbitrate between two, as is often the case, between two extremities, of the way people were putting the argument. Whereas if we're actually looking at what the bargain was, we need to look at clause 4.2 and understand it in the context of
Yes.
company law and insolvency.
As I've indicated to your Lordship, what I said will be what I said, but I do recall putting it in the way that is reflected in the paragraph that I've just shown by Ladyship, to the effect that our decision was a decision taken for the most compelling commercial reasons.
Yeah, I get that.
I didn't need
No,
to
but I
go
get
into
that.
the
But we're
length.
just focusing at the moment in your roadmap on what was the bargain.
Yes.
So supposing that the judge was right, that the clause 4.2 duty included within it an obligation of fidelity to the bargain, but then, as you say, ask ourselves what the bargain is. The judge finds the bargain is, well, Dr. Sachs and Mr. Faulkner have to remain regardless. You say, well, supposing that the bargain was that they had to remain in some circumstances. It didn't extend to them remaining in these circumstances where you'd put in all this money, you'd lost confidence in Dr. Sachs, and you had a bona fide belief that it was necessary in the interests of the business for Dr. Sachs to go. And if you relate that to the legal documentation and company law principles, first of all, there are duties, at least on directors, to act in the interests of a company and potentially in the interest of creditors if the interest of creditors intrude. You also, of course, have, as the judge recites in paragraph 386.6, the provision saying, providing for directors to cease to hold office by virtue of any provision of the 2006 Act.
Yes, which is a point I'm going to come back to, which is of considerable significance, because in fact, what the judge has concluded at subsection 6 of his paragraph 386 is that the articles in this case actually embedded the statutory right of removal under section 168. So whether you approach it as a question of implication of terms or whether you approach it on some different basis as to what the party's bargain, quote unquote, is to which the duty of good faith mandates fidelity, our submission to the judge, and certainly to this court, is that an integral component embedded in the articles is recognition of the right of the shareholders to remove Dr. Sachs.
Yeah.
So I'm now coming on to address 4 square by reference to the contractual documents, this concept of what the bargain is in this case. And as I say, it is, for our purposes, a matter of indifference whether you approach this as a question of implication or whether you approach this on a more general basis of what the bargain is in the context of construction of clause 4.2. And the first question we suggest that the court has to engage with is whether the duty of good faith has relevance at all to how we used or threatened to use our statutory power to remove Dr. Sachs. We haven't gone yet to the shareholders' agreement, but I'll take you to that now in the core bundle in the second volume at bundle 2. It's at tab 20.
Was this? I haven't picked this up in your skeleton. Was this a point taken in your skeleton?
No, it's not. I should fairly accept that. We did make submissions to the judge below in relation to the scope of the provision.
I understand that.
And
but you're now saying, is it actually engaged at all, an entry threshold point? All right.
It is not.
Okay. So, sorry, where are we going?
Second core bundle, tab 20.
Thank you.
So, page 533, the first page, just to point the contrast to Yam's saying, this is a detailed agreement running to some 70 pages in all, and you can see from the front sheet looking at the top right, prepared by Norton Rose, and in fact Farrers acted for Cpgl. And clause 4.2 itself you find on bundle page 544.
Well, your short point is that section 168 removal isn't a dealing with shareholders or with the company.
Forgive me?
It is the section 168 removal is not a dealing with other shareholders or with the company. Is that your point?
It's a slightly different point.
Right.
It's in fact that the exercise of shareholder power is dealt with under a different specific provision rather than 4.2. But I was just going to start.
No, all right.
I was going to start, if I may, just by showing you the section itself, the clause itself, 4.2 in the middle of the page. Each shareholder undertakes to the other shareholders in the company that it will at all times act in good faith. And just for your note, I don't attribute any significance to it, but if you turn back a page to 543, you'll see slightly oddly that this provision sits in a section entitled Warranties. And just looking at 4.2 itself, it says nothing about the exercise of rights under the Companies Act, still less about the exercise of the specific right of shareholders to remove directors. And we respectfully suggest that in the context of a professionally drafted agreement, that would be a pretty oblique way of to control the exercise of that right. And that is all the more so because other provisions of this agreement touch on how discretions conferred by the legislation are to be exercised. And if you turn on to bundle page 550, you can see there's a section 13 of the agreement which deals specifically with how the discretion to pay dividends under the Companies Act is to be exercised. Except by itself, that is a comparatively slight straw in the wind. But rather more relevantly, if you turn on to bundle page 576,
So 576.
please. You have another provision which we respectfully suggest that clause 4.2, simply not dealing with the question of how shareholders can exercise their powers to vote directors off the board. Clause 21, parties bound, skip 21.1, 21.2, the shareholders undertake with one another to B, exercise their rights as shareholders in a manner consistent with the agreement. So this is a specific provision going beyond, separate to the obligation of good faith, specifically speaking to how the shareholders are to exercise their rights under the
Does that become a bit circular? Because you're exercising your rights in a manner consistent with the agreement. You might be said to be exercising them in a manner consistently with clause 4.2. And then it doesn't seem to matter whether clause 4.2 sort of applies directly or via clause 21.2.
I can see the force of your logic's point. So
Is this actually an argument that was put to the judge?
there certainly was an argument put to him in relation to scope. I can't honestly say that I recall whether or not I put it in this way. But in fact, when we go back to how his lordship dealt with the authorities, you'll see that one of the questions, the first question in fact he addresses is the question about scope.
Well, the judge identified the question, which I asked you about earlier in 347, as being whether 4.2 restricted the right of the shareholders to remove a director. Doesn't seem to have been addressed or turned his mind to the logically prior question, which you're now addressing us on, which is whether 4.2 is the relevant clause at all.
He does it.
A bit surprising if somebody had made the point to him, he wouldn't have, in a very careful judgment, picked up logically the prior point.
I cannot honestly say I remember putting the point to him in the way that I'm putting it to you now, but I certainly did make a point about scope. But I will move on because I see the force of the point of Justice
Okay.
Newey.
Otherwise, I'd have asked you another question.
Yeah, I'll move on. So I
Yep.
accept that point. So leaving that point aside, the more general question is whether there is inconsistency with the obligation of fidelity to the bargain and the bargain as it is actually expressed in this agreement, the articles, and Dr. Sachs's employment contract. And so far as that is concerned, we suggest to the court that the starting point for analysis has to be the provision which you find over the page at 577. Clause 23, headed not a partnership. Nothing in this agreement shall create a partnership or establish a relationship of principal and agency or any other fiduciary relationship between or among the parties. So the parties have expressly agreed that their relationship is not one of partnership. And if you look on skipping 24 to clause 25, you'll see that provision is fortified by some fairly comprehensive entire agreement provision at clause 25. Start by just noticing, if you would, the definition of the term pre-contractual statement in clause 25.3, bottom of the page. Any agreement undertaking representation, warranty, promise, assurance, or arrangement of any nature. So that's in the widest possible language. And then having read that, look back please to 25.1 A and B, if I can invite you to read those to yourselves. what do we say follows from the no partnership provision that you see at clause 23? The key point is that in equity until 1890 and pursuant to statute after the Partnership Act of 1890, partners have various default rights absent contrary agreement. We've in fact included the material provision in the authorities bundle, which is section 24. It's at tab 39, bundle page 1878. But I'm not going to propose to take you to it.
Sorry, can you just, I know it'll be on the transcript, give me that reference a little bit more slowly.
Forgive me. File 6 of the authorities bundle, tab 39, page 1878.
And this is the authority which is not quite where one would expect because it's been put in place of another authority.
Yes. And that is the general provision that sets out the default rights that arise as between partners absent contrary agreement in the partnership deed. And I don't propose to take the court to it because the uncontroversial proposition is that one of those default rights, the key default right, is subsection 5, giving the partners individually a right to participate in management, subject to express contrary agreement. And we respectfully suggest that the whole point of clauses such as the one that I've just read, clause 23, is to exclude that default right of management.
Does it not go beyond that? Because they're not just saying no partnership, they're excluding fiduciary relationships. I mean, they want to exclude fiduciary duties.
Precisely. So what this clause is also saying, and this is highly relevant to how one approaches the question of what is the construction of the obligation of good faith. On its terms, the contracting parties are entitled to have exclusive regard to their own interests in how they act.
Well, this is the, I mean, so the starting point as a matter of company law, as I understand company law, is that a shareholder can vote his share as he sees fit, in his own interest, and perhaps in a way that might be regarded by other people as irrational. In other words, he could, if he wanted to, say, I don't want like directors with red socks.
Yes.
Now there may be some equitable curtailment or other curtailment of that right by, for example, 994 principles that have been developed in case law. But the starting point is it's a property right to be exercised as the shareholder sees fit. And he doesn't owe fiduciary duties to other shareholders or to anybody else to have regard to their interests rather than his own when exercising that right. Is that?
Yes.
Now, what's the clearest statement authority that you have?
I don't
of that
remember the
proposition?
decision, but I know the decision that your lordship is thinking of. Before, I mean.
Okay, well, I'll leave you with it.
I have in mind that there's Mr. Justice Dixon in the case called Peters, isn't there? And I think it's reflected in the Supreme Court decision, which I might not otherwise welcome, for reasons that will become apparent if you look at it in Lady Mackey, Children's Investment Fund and Lady Mackey.
Yes. And I should just make this point as well, just whilst we're on this clause 23, one of the points that we made to the trial judge, and in fact it's a point we also make in our skeleton argument, was by reference to the decision of my Lady Justice Carr in a case called Fujitsu, which does engage with this question of the dividing line between the obligation of good faith and fiduciary duty. And in that case, Her Ladyship, by reference to some academic writings, as I recall, by Professor Koenigsegg, made the point that the duty of good faith is not of itself fiduciary.
Which itself is debatable, but doesn't matter for this purpose.
The obligation of good faith may be an incident of the fiduciary relationship. That's a different point. And what you have here is a contractual relationship between two parties who expressly provide that the relationship is non-fiduciary.
Yeah, but it's a potentially one-way street. I mean, you say, if you undertake an obligation of good faith to somebody, you say that doesn't mean that you're a fiduciary for them. And so the provisions of this agreement are not inconsistent when they say there's a duty of good faith, but it's not a fiduciary duty. But if it was the other way round and you have a fiduciary, inevitably follows that he has to act in good faith to his beneficiary.
Absolutely right. And that's a point we're going to come on to when we go through the authorities by reference to a number of decisions, including the decision of this court in Medforth and Blake.
Yeah, again.
Because the concept of good faith is in origin an equitable concept. And so when you see it expressly provided for in a contract like this, what the draftspersons are doing is to incorporate a doctrine which has arrived as an equitable doctrine of conscience. So my starting point for analysis is the provision I've just shown you, not a partnership in clause 23. And we say that that provision of itself tells against the suggestion that any shareholder, any individual shareholder, has a right to manage which is enforceable against the wishes of the majority to general meeting. And we rely on three specific aspects, further aspects of the contractual framework, more generally for that proposition. Now, the first is the provision of Article 15, which you've seen reference to in the judgment, and which you'll find over the tab at tab 21 at bundle page 598. And in fact, the relevant extract is at page 605, bundle page 605. I want to start it off at 605. As my Lord Justice Newey pointed out, there was an original suite of agreements in 2010, superseded in 2013 with relatively light touch changes. On 605, I only take you to this to make good the point that this document, these articles, this statutorily enforceable contract, was concluded with the shareholders' agreement in specific contemplation. And you see that by the second defined term on this page where it refers to the shareholders' agreement. So these documents were executed in contemplation of each other. And then turning on to bundle page 622, should have a section entitled Disqualification and Removal of Directors. And this replicated identical provision in the 2010 articles. For your note, it was Article 13.1, which you would find at tab 19 of the core bundle, page 522. So the provisions you're about to look at were a feature of the shareholders' relationship throughout. And if we started off at 15.1, subject to Article 15.2, the office of a director shall be vacated if A, he ceases to be a director by virtue of any provision of the 2006 Act or these articles, or becomes prohibited by law from being a director. And then at 15.1e, you'll see there's of course a statutory power, the statutory power of members to remove a director. 15.1e also enables the board by majority resolution to remove a director. The office of director shall be vacated if E, the board passes a resolution to remove the director. Then if you look onto Article 15.2, you'll see that Dr. Sachs, he's the chief executive in this document, and Mr. Faulkner, he's the founder director, were exempt from removal by that specific means. The board shall not be able to pass a resolution to remove Dr. Sachs as a director or Mr. Faulkner, and nor shall those individuals vacate the office of a director if they make any arrangement or composition with creditors. So Dr. Sachs and Mr. Faulkner are specifically exempted from removal by board majority resolution, but that is the only special protection they are given. So they are removable by the means contemplated by 15.1a, which I read out at the start. The office shall be vacated if the director ceases to be a director by virtue of any provision of the 2006 Act. And if you just keep this file to hand for a moment and dip back into the judgment to see what the judge said about this, back in the other volume of the core bundle, tab 8, at bundle page 166, please. 166.
Thank you.
And you see at the foot of that page, so this is the paragraph I said I'd come back to the detailed subparagraphs later. And then at 4, you see he talks about other protections built into the overall arrangement to ensure Sachs and Faulkner couldn't be removed. 5, not to retire by rotation, exceptionally unlike other directors, neither could they be removed from office by resolution of the board. Then over the page he says this at 6, thus they were to vacate office only in the other more limited circumstances identified in 15.1. They include bankruptcy, resignation, 15.1a, on their ceasing to be a director by virtue of any provision of the 2006 Act. Then this, it seems clear that any provision of the 2006 Act includes by virtue of any resolution of shareholders passed under section 168. And we say that it is crystal clear that 15.1a in the company's articles are sufficiently wide to encompass removal by means of a section 168 resolution, and the judge himself unequivocally accepts that in his judgment. So in his discussion of what the company, what the balance is, what the constitutional balance, the constitutional settlement is, he expressly accepts that the possibility of removal under section 168 is embedded in the articles themselves. So on his own reasoning, our statutory right to remove Dr. Sachs was, as he describes it, the judge describes it, inalienable, and expressly embedded in the 2013 articles. And we say that it follows from that that it is simply impossible to conclude that our March 2016 threat to use that right to oust Dr. Sachs was inconsistent with the agreement or with the constitutional settlement to which the judge thought the obligation of good faith mandated fidelity.
There's a danger that that argument goes too far around, as Lord Justice Snowden was suggesting, because if you look no further than that provision of the articles and say, well, the constitutional settlement is such that you can use section 168, well, you can use it in any circumstances. That seems a rather far-reaching submission. I mean, you can use it however unreasonable, unjustified, ridiculous your reasons are for removing Dr. Sachs.
I accept that there is an outer limit set by the obligation of good faith. And your Lordship has our submission as to what that outer limit is. And were I obliged to, I'm sure we could suggest examples to the court of what would have been improper. Removal of Dr. Sachs for some collateral reason as a result of some thoroughly improper bad faith trumped up allegation of misfeasance, something like that, would plainly have been an infringement of the obligation of clause 4.2. But at this stage of the argument, the judge is addressing the hard-edged question of whether Dr. Sachs can be removed at all. So Lordship has seen from our skeleton argument, the only exception the judge contemplates, and then only in passing, is the possibility of removal in proven misfeasance. But at the stage of analysis at which he's evaluating the question, what is the bargain? What is the constitutional settlement?
That's the phrase where it's, forgive me for interrupting, he says something like absent misconduct or something.
Yes.
I've been searching for the paragraph. Could somebody at some stage just remind me which?
418 to 419, which we accepted. That was part of our submissions, that they were removable on the grounds of misconduct. Which is why we borrowed we used probably, perhaps inappropriately, the label of a contractual quasi-partnership, so as to incorporate all the principles in quasi-partnership where you can be removed for misconduct.
Yeah.
So, analysing the parties' bargain, so far I've drawn the court's attention to two particular features of it: the no partnership provision, clause 15.1a, with its embedded reference back to section 168. And in our submission, the analysis that I'm propounding is corroborated by this further feature of the contractual framework, which you find if you look in the second volume of the core bundle now, tab 16. This is Dr. Sachs's employment contract.
Just before you get to the employment contract, the articles are a publicly registered document, correct? The shareholders' agreement, was that registered at Companies House?
Not as far as I'm aware. I'm sure I can be corrected if I'm wrong, but not as far as I'm aware.
So it's impermissible to imply a term into the articles from the shareholders' agreement, isn't it?
Forgive me, I'm not sure I quite have your lordship's point.
I think it's pretty clear from cases mentioned in Belize Telecom that there are restrictions on implication
Yes.
of terms
I understand
in
that.
articles of association because they are a publicly registered document and you can't rectify
Yes.
or imply terms into a publicly registered document save on the bases of matters that are known to the world at large.
Right.
That's Belize Telecom to the extent Belize Telecom survives, which I think does. This bit does survive. The savaging that it got in Marks and Spencer. So, how is that relevant? And if we're about to look at another document, which is not a publicly registered document, it probably does make a difference. You said earlier today that it probably didn't make a difference whether you approach this as a matter of construction or a matter of implication. I think it probably does.
I understand your lordship's point. So your lordship knows where I'm going. I've taken the point that if you look at the articles, they embed the right to remove Dr. Sachs.
Yeah.
And the point that I'm going to make in a moment is that you see precisely the same point if you look both at his service agreement and at the shareholders agreement in addition to the no partnership provision which I showed you. So they all head in the same direction. I don't think the judge suggested, well, there's a question of whether the judge regarded this as an exercise of implication or an exercise of construction. But either way, what he was focusing on was the construction of clause 4.2 in the shareholders agreement. Now, the articles, publicly registered and they say what they say, are plainly relevant to the construction of the shareholders agreement. There may be a question about whether the shareholder agreement...
I mean, it may not make much difference, but the judge keeps referring to the 2013 Constitution as if it's a unitary concept. As I currently understand it, you have the Articles of Association, which are binding on the company and the shareholders, which operate against the background of the Companies Act. What you can do in what the company can do and what shareholders are bound by as a matter of basic company law is to be derived from the Articles and the Companies Act. What individual shareholders might bind themselves further as a matter of private contract between themselves in relation to how they will exercise their otherwise unrestricted powers is a separate question, as between the shareholders.
Yes.
And possibly, query, as between the company, subject to the argument we had earlier on Northern Russell and Northern Development Bank about the extent to which a company can bind itself. But I'm trying to keep what the judge has treated as a composite a little bit separate.
I entirely understand your lordship's point, and it's not a point which I confess was argued before him, so the failure may be mine, in not making that distinction to his lordship at first instance, which is why you don't find any trace of it in the judgment.
Although it is to some extent inherent in the way that you're approaching it now, because you start from the proposition of the articles as a foundational document, and you say, look, the power to exclude under section 168 is hard baked into the articles in the way that you just described. And you're going to show us the employment contract and make a similar point. But for 994 purposes, the judge says, yes, it goes, when we're looking at what the bargain is, we can start looking at the shareholders' agreement as well. I mean, that must be right for 994 purposes.
Yes.
Yeah.
The only qualification I would make to your Lordship's point in relation to the Belize Telecom case is I can see that there might be an argument about whether the shareholders' agreement is admissible to any question of construction of the article, because the shareholders' agreement is expressly referenced. But with respect to your Lordship, on my submission, the point simply doesn't arise, because on the articles, there's no question of ambiguity. The power to remove is, as your Lordship put it, baked in, and even the judge accepts that. So what I'm moving on to now is the question of whether there is anything either in Dr. Sachs's service agreement or in the shareholders' agreement to displace that conclusion. And I've already made one submission in relation to the shareholders' agreement, which is the no partnership provision. It's rather often glossed over as boilerplate, but if it has a meaning at all, it is to exclude the right to manage that would otherwise arise by virtue of section 24, subsection 5 of the 1890 Act.
Can I just flag one other point, not to be explored now, but in case it matters, and I don't think it probably does matter to any real extent, but I see that the judge accepted the submission that the company's constitution, for the purposes of section 171, means the articles and the shareholders' agreement. I'm not sure I fully accept that. That's a problem for later on, perhaps.
I recall that there is a statutory provision in the 2006 Act that springs that conclusion.
I'm not sure it does.
Is it not? Right, okay.
Section 17.
17 was what I had in mind.
Which takes you to another provision, and I'm not sure that it quite says what the judge assumed it says. But anyway.
I mean, it may not be a point that signifies. Because whether you regard the shareholders' agreement as a part of the company's constitution within the Companies Act definition, if there's been a breach of that shareholders' agreement.
It might matter for section 171, so far as section 171 matters.
So, my Lord, I'm going to come on to the other two features of the contractual matrix that we rely on as pointing in the same direction. You have open in front of you Dr. Sachs's service agreement. Start by noting, if you will, that he's actually an employee of Compound Photonics US. That is a wholly owned US opco of Compound Photonics Group Limited. And you see this agreement derives from 2010, so this derives from the initial suite of agreements, and it remained in force throughout. And it's crucial to note, and this is an important point, when this agreement is concluded, Vollin was a minority shareholder, had 30%, give or take, of the voting rights. See paragraph 43 of the judgment. So, looking at this document, what does it tell us about whether in 2010 the 70% of non-Vollin shareholders could have removed Dr. Sachs from the Cpgl board? Now, I've already made the point to the court that Article 15.1 in the 2013 articles, which I showed you, had a direct counterpart in the 2010 articles, and I'm not proposing to show them to you separately, they're identical, preserving the statutory right to remove directors. And if we now look at this agreement, we see that that right is expressly reflected here too. Start off, if I may, by taking you to a couple of provisions at the tail end at page 425. Boilerplate they may be, but important they still are. 22.2, reading it in the third line. This agreement shall constitute the entire agreement between the company and the executive relating to the employment of the executive. 22.3, if there's any conflict between the terms, conditions and provisions of this agreement and any other document, the terms of this agreement shall prevail. So this is the controlling agreement. And with those provisions out of the way, if you go back to bundle page 416, please. And 416 over the page at 417, what you can see here in broad terms is that Dr. Sachs's employment can come to an end in one of three ways. First of all, looking at clause 12.2, you can see that the company may terminate this agreement for capital C cause at any time on written notice effective immediately, and cause is defined down at 12.2.1. We don't need to get into the weeds. It's what you would expect it to say. It's for misconduct and the like. Secondly, turning over the page to page 417, you can see at clause 12.5, the company may, by a majority vote of Compound Photonics Group Limited, also terminate this agreement for any reason on 1 year's notice and may relieve the executive of all duties of the company at any time. So that is a power to terminate without cause on 1 year's notice, with the option of paying the executive in lieu of having him or her workers notice out. And then up the page, just above the first hole punch, you see at clause 12.3, the executive, Dr. Sachs, may terminate his employment with the company under this agreement for any reason on 1 year's written notice. And it's worth just dwelling on that clause for a moment, because one of the planks in the judge's reasoning as to his conclusion that Dr. Sachs couldn't be removed at all was that he was the jockey the shareholders all agreed to back. Just for a note, that was paragraph 384, Roman 3 of the judgment. That this agreement tells you that the jockey himself concludes his horse is a dud. He's entitled to leave the race at any time. Then moving on to page 421.
The executive, is that defined? That's obvious, is it?
Yes. It will be.
It's not in the definition section.
It will be in the recyclers.
Yes.
408.
Yes, thank you. So that's. Yes.
408, number 2.
Thank
top.
you. Thank you.
Can you just explain to me, as a matter of concept, how 12.5 works?
Yeah.
How does a decision on behalf of the company, is it an agency relationship or something? I mean, how does the board of Cpgl Limited make a decision for the company?
It's not a very smart piece of drafting. But it may well be that what has to happen is that Cpgl makes a decision and then CPUS imports that decision and makes one of its own. I accept that it is not without its difficulties, but the intention behind it is, I suggest, reasonably clear.
Yeah.
And the point that I was going to next with your lordship is one that you get to if you turn on now. Give me, I've lost my place. Yes, paragraph, page 421. And the important clause here is 15.1. Can I ask you to read that to yourself? And I'll just remind you, if I may, when you see the company in the first line, that's CPUS. So that's not Compound Photonics Group Limited. I can ask you to read that to yourselves. So the provision is in two parts. The first is dealing with what happens to Dr. Sachs's CPUS directorship in the event of the cessation of his employment. But the important one for our purposes is the second, which is what happens to his Cpgl directorship. Maintain his position on the board of Cpgl unless otherwise removed in accordance with the articles. And it makes no difference to that whether his removal has been as a result of resignation or removal by involuntary means. And if involuntary, you'll note it makes no difference to what happens whether he's been terminated for cause or for no cause. In either case, he is liable to be removed under the articles from the Cpgl board. So the bottom line is that Dr. Sachs has agreed in this agreement that a majority board vote suffices to remove him from his employment, and that he can thereafter be removed from his Cpgl directorship pursuant to the articles, which have the section 1681 right baked in. And I'm going to suggest we see precisely the same point if we move on to the next construction point that I wanted to address you on, which is a final point arising out of the shareholders agreement, but I note the time.
How long will it take to do that one?
Well, it's going to take more than a couple of minutes to 1 o'clock. One point I would just make, if I may, which is on my present run rate, I'm fairly significantly behind where I'd hoped to be by lunchtime.
Unless Lady Justice Carr or Lord Justice Snowden has a problem, I'm inclined to ask you to deal with this point now.
So,
Yes.
So this is the next and final of the construction points that I'm taking in relation to the constitutional settlement, and that requires us to go back to tab 20, which is the shareholders agreement. And this time the material passage, we need to start by noting a definition on bundle page 536. I've made the point a number of times that there is an original set of agreements in 2010, redocumentation in 2013. The reason for the 2013 redocumentation was that it was originally anticipated that the exit date for the investors would be, I think it was August 2014, at any rate some point in 2014. So by 2013 it was pretty clear that wasn't going to be met, and the agreements were revised to give effect to that. And the core difference between this and the 2010 counterpart is the introduction of an incentivizing class of B shares which are given to the managers. And my lord can see that if you look at page 536, you can see a whole series of definitions in relation to the B shares. Just beneath the second hole punch, B shares offer letter means the offer letter delivered to management, capital M. And if you turn a few pages on to bundle page 540, at the top of that page, management means Dr. Sachs, Mr. Faulkner, and a Dr. Lind. Then turning on to bundle page 564, we'll have the start of a section 16 dealing with compulsory transfer and disenfranchisement, which is quite a lengthy section. And it suffices for our purposes to give you the flavour of this by asking you to look at clause 16.15 on bundle page 569. And cutting to the chase, if you leave, you lose your shares. But if you're a good leaver, 16.15 clause B, you lose 50%. If you're a bad leaver, subclause A, you lose all of them. So different consequences follow depending on whether a shareholder is a good leaver or a bad leaver. Definition of good leaver, you find at bundle page 565. Just beneath the second hole punch, good leaver means a B shareholder who ceases to be a director, employee, or consultant. And just note that those are plainly disjunctive. So either director or employee or consultant of the CPG group, and that cessation occurs as a result of. And then A and B don't matter, but look at C and D, they would what you would expect, wrongful dismissal, termination of the relevant CPG group company of his service agreement. And then there's a matching definition of bad leaver, back a page on 564, closing the loop. bad leaver means a B shareholder ceasing to be a director, etc., where he is not a good leaver. So between the two, they exhaust the whole ground. So this whole section, section 16 of this agreement, is addressing, among other things, what happens to Dr. Sachs or Mr. Faulkner's B shares in the event they are removed from the board. And we say that is a clear pointer of itself within the four corners of the shareholders' agreement to the conclusion that they did not have the immunity from removal, which the judge thought that they did. Now, we made precisely this point to the judge below, and it's worth just taking a moment to look at how he dealt with it. If I can ask you to keep the shareholders' agreement to hand, but look now in the first volume of the core bundle, back in tab 8, bundle page 169. Where he says this, at its highest, he's just referred to the various points that I've addressed to court now. And he says at its highest, all that is said is that there would have been no purpose provided for what should happen to Sachs or Faulkner's B shares upon their being removed as directors, if the correct position is that they could never be removed. The short answer, again, is they always could be removed by the majority shareholder vote. There was nothing to be done to prevent that. But that is not the same thing as saying that if they were, there could be no claim for unfair prejudice. And that is the point which my Lord Justice Snowden was asking me about a little while ago. And we respectfully suggest that this reasoning discloses a fundamental error in approach, which derives from the judge's acceptance of my learned friend's radical submission. Because there is a contractual duty of good faith here, the position is somehow analogous to a quasi-partnership company.
He doesn't say this, but presumably the judge had in mind that although the removal would be effective, it would be a breach of contract, a breach of the obligation of good faith.
Yes, exactly.
And hence the unfair prejudice.
Exactly. But in our submission to this court, it is one thing to say in the context of quasi-partnership that the members of a company have created legal rights as between themselves on which equity superimposes a gloss. Classically, having regard to the fact that the nature of the relationship has been insufficiently captured in standard Table A articles. But we respectfully suggest that it is quite another thing to interpret an elaborate, professionally drafted suite of shareholder agreements to create a right which, rather like Schrödinger's cat, is simultaneously both there and not there. On ordinary principles, one does not construe a contract as expressly permitting the exercise of a power by one provision, but obliquely rendering its exercise wrongful by another. I know that may be a convenient.
I mean, just going off on a tangent, I suppose that's sort of what you get with employment contracts. If people are wrongfully dismissed, that doesn't mean that they can insist on continuing to work, but there's a claim for breach of contract.
But in that context, there is a breach.
But what you say here, I think, is that if the judge was right in finding that there is a contractual inhibition on the exercise of Section 168 powers as between Dr. Sachs and Mr. Faulkner and the other shareholders, there's no reason why, in fact, that couldn't be enforced by injunction,
Yes.
permanent injunction. And in other words, the court would be faced with the claim that as between the shareholders, they were irremovable.
Exactly.
Or as a matter of pure commercial construction, very odd to have within a single composite document, giving on the one hand and taking away on the other.
Exactly.
As a matter of construction of a single clause.
Exactly.
or couple of sentences.
If there is a contractual right to entrenchment on the part of Dr. Sachs and Mr. Faulkner, The correct position is either Dr. Sachs or Mr. Faulkner, when we threatened to remove, could have sued for an injunction. I'm not taking a point about their failure to do so, but the point that I'm making is that if there is a contractual right that gives rise to the possibility of saying I have been unfairly treated for the purposes of the unfair prejudice remedy, it must follow that that contractual right is enforceable. And the possibility of such an enforceable right is flatly inconsistent with the Section 168 powers inclusion in the articles, which is then reflected in both of the two documents that I've shown to the court.
Well, again, at the risk of taking it further at 1:10, I'll just mention it, but it could be critical to a minority shareholder to remain as a board member and involved in management in order to protect the value of their shareholding in situations which are frequently encountered where the company is about to embark upon something very profitable, about to get a very good deal, which simply would be lost, save in a retrospective valuation, were they actually to be removed and have to bring unfair prejudice proceedings and subsequently to, as it will, get disclosure and evaluation based upon what would have happened had they remained. So in other words, I understand you're not taking the point about what actually happened in this case, but we must test the argument, I think, by reference to the potential remedies that would have been available and how it might play out were the judge right in another case. It could have happened differently in this case.
Yes.
And that's the test you're inviting us to apply, to say, look, it can't be right because it would have cut across all these other provisions.
Quite.
And given right, yeah. Okay. Yeah.
So,
That's thinking out loud, so sorry about that.
having, I'm afraid, imposed on everybody 10 minutes extra hearing into their lunch break, we'll break now and resume at 2 o'clock.
All rise.